The position of Islam in the Constitution of the Federation of Malaysia. The Federal Constitution of Malaysia states that Islam is the religion of the Federation. This provision in Article 3 Clause 1, inserted in 1957 when the Independence Constitution was framed for the Federation of Malaya. When the new Federation of Malaysia was formed in 1963, under paragraph 15 Clause 1, under the heading Religion, it has been specifically agreed that no amendment is required to Article 3 Clause 1, which provides Islam is the religion of the Federation, but other religions may be practiced in peace and harmony in any part of the Federation. This provision has drawn considerable scholarly attention in recent years. Most of the studies, however, have not been able to consult the primary constitutional documents. Invariably, many have given varied and ambiguous interpretations of the provision. This video examines the primary constitutional documents and constitutional debates between 1956 and 1957 to trace the origin of Article 3 Clause 1, and to determine the intentions of the framers in inserting this provision in the Constitution. Article 3 Clause 1 of the Federal Constitution of Malaysia states that Islam is the religion of the Federation, but other religions may be practiced in peace and harmony in any part of the Federation. This provision has drawn considerable debate in recent years from scholars, politicians, lawyers and the general public in Malaysia. Varied interpretations of the article have surfaced in recent years, and the provision in the Federal Constitution continues to be widely debated from time to time because of its perceived ambiguity. Most scholarly work on the issue, however, has been based on information derived from a reading of the published material available on the Constitution, the report of the Reid Constitutional Commission, the White Paper on the Constitutional Bill, Federation of Malaya Legislative Council Paper No. 42 of 1957, parliamentary proceedings, newspaper reports and judgments handed down by the courts in the post-independence period. The Reid Commission, which drafted the Federal Constitution of the Federation of Malaya between 1956 and 1957, was chaired by Lord Reid, an appeal court judge in Britain. The other members of the commission were Sir William McKell, a former Governor-General of Australia and Cabinet Minister, Sir Ivor Jennings, a constitutional expert and Master of Trinity Hall, Cambridge, Justice Malik, a former Chief Justice of the Allahabad High Court in India, and Justice Abdul Hamid, a High Court judge and former Secretary to the Ministry of Law in West Pakistan. The commission, which was appointed following agreement between the Alliance government, the Malay rulers and the British government at the London Conference in January 1956, took evidence in the Federation of Malaya from political parties, organizations and individuals from June to October 1956 before traveling to Rome to prepare the draft constitution. The draft was published on the 20th of February 1957 and submitted to the Alliance government, the Malay rulers and the Colonial Office simultaneously. None of the existing works have examined adequately the primary constitutional documents to ascertain the intentions of the framers. These documents include the minutes of the Working Party, which reviewed the Reid Commission's draft constitution, the documents relating to the constitutional talks in London in May 1957, the constitutional papers of the Alliance Party, and Colonial Office documents relating to the constitution-making process. This article seeks to fill this gap by examining these primary documents to provide a clearer picture of the intentions of the framers. For a proper understanding of constitutional provisions, a study of the primary documents is essential. A constitution is not only the product of political and socio-economic forces operating at the time of its framing, it is also about the intentions and motives of its framers. Thus the historian's tools, a chronological examination of the debates, the disputes and compromises between the framers, are indispensable to a fuller understanding of the meaning of Article 3 Clause 1 of the Federal Constitution. This approach allows latitude in examining more directly the evolution of the article and the debates surrounding it at the different stages of the constitution-making process. As Kenneth Weir has noted, to understand the significance of the document, we must look beyond the formal legal phrases to discover the predominant forces in the framing and adopting of a constitution. The articles of a constitution are often ambiguously couched in cryptic legal parlance, and it is here that the historical approach is most useful in unraveling the ambiguity of the legal phrases through a close scrutiny of the documents.